What are the most common mistakes that people make when protecting their homes?
There are a few common mistakes. The most common one is that they do nothing to protect their home equity, right? Which means that they're either holding their home in their own name, or they are incorrectly relying on their estate plan, what most people call a revocable trust or living trust or family trust. And they are under the mistaken belief that because the home is titled in that trust, that it is protected from their creditors. And that's unfortunately not the case for any revocable trust. So that mistake number one, doing nothing. And that, as I said, that typically means you either have it in your own name or in the name of your estate plan.
So someone thought, hey, an attorney drafted up a trust for me, I should be good.
Exactly. And look, that's not a criticism of the trust. I use that tool every day.
Right.
It's a great tool, but a saw is not a hammer, right? So it has to be the right tool for the right purpose, which is a perfect segue into the next very common mistake. Then there are folks who act but use the wrong tool, right? So they might use, for instance, an LLC and put their primary residence in it under the impression that the LLC is going to protect them. Unfortunately, to use an LLC that way requires that the LLC is legitimate, that it has formality, that it conducts some legitimate business, right? So merely setting up an LLC or putting the home that you live in into it with no other legitimate business purpose, or people do the same thing with their cars sometimes, is unfortunately amateur asset protection that does not work.
So someone that goes on a LegalZoom and says, hey, I bought an LLC, and they think they're all good now, doesn't work.
That's correct. Now, there are absolutely circumstances where an LLC is the right tool, and we'll get into that maybe in a minute. But for most people, that's not a good option. Another thing that we see people doing that is a mistake is if one spouse is higher liability than the other. Sometimes they feel they have created a situation where they have family asset protection by titling assets in the name of one spouse only.
Yeah, we see this quite a bit.
Right? And I will say that it is in many cases men who say, I don't own anything, my wife owns everything, right? And so that's a very common approach that people take, and unfortunately that doesn't work either for a number of reasons. Number one, we're in a community property state, right, as you know.
Sure.
So regardless of who holds title, it's still community property, absent things like a prenup, a postnup, a property transmutation agreement, perhaps that says, hey, this property was the property of Mr. and Mrs. Smith, but now it is entirely Mrs. Smith's separate property.
What about inherited property?
Inherited property is separate property, and it's the property of the inheriting spouse. But in the cases where somebody is just saying, I'm the risky one, my partner is the safe one, I'm going to put the assets in their name, that fails for a number of reasons, as we said. Number one is the community property issue if we're talking about spouses. Other issues are the fact that, for instance, if that person then gets divorced and they have taken those steps and transferred that asset to their spouse, that asset is no longer part of the community that will be divided. Your spouse will get the house and half of everything else.
Not the outcome they were looking for.
Not the outcome you were looking for. And on a similar note, that spouse and all of their liability is carried to that property, right? So if you gave your property, for instance, to your wife, and she left you or got sued or went bankrupt or was in an accident or anything else, that home is still exposed to her liability, right? So we see that happen time and time again, where people rely on the spousal transfer. And the last common mistake, which is combined with the LLC mistake, is the one that I call the myth of secrecy. You know that there is no such thing as the word secret in the law, right? There is such a thing as privacy, and in some cases we use LLCs to create privacy for the buyer of a home. Maybe a client that I or you have is a high-profile person who has a physical security concern. Or maybe they don't want the seller to know who the buyer is because they are high net worth and high profile and they have price inflation.
Yeah, it always surprises me when I talk to clients about this and they don't realize there's options to not end up in all the local publications when you buy something.
Right, and every home purchase of over $400,000 is now published with the name, address of the buyer. And you will see three options in those cases most of the time. For instance, in the Phoenix Business Journal, as one example, you will see either the name of the buyer, or you will see the name of the LLC that they used, which again, we've already addressed why that's not a good idea. Or you'll see the name of their living trust and it will say so-and-so trustee.
In their name.
In their own name, right? So for instance, when we create revocable living trusts, which we know might be used for that purpose, we won't put the Robert Altshuler Trust as the name of the trust, right? And so, yes, we totally get and agree with the idea of privacy. And I like privacy as a tactical issue. It's good to look smaller than you are and not have everything you own easily identifiable from my perspective as the asset protection attorney, right? I'm a hammer, so the whole world is a nail. So I'm looking at this issue on every transaction. But the effect, if push comes to shove in a courtroom, we need to have something that's actually going to stand up. And so relying on secrecy, whether it's because you used a Wyoming LLC or because you have it in someone else's name or did something else, again, not real asset protection.
Makes sense.